Good afternoon, everyone. I would like to welcome you to the 24th meeting of the Standing Committee on Aboriginal Affairs and Northern Development. Today we will be continuing with our hearings regarding Bill C-30, an act to establish the Specific Claims Tribunal and to make consequential amendments to other acts. And we have a very full house here today, so welcome to all of you, both our large number of witnesses as well as those in the room today. I only point that out because there are actually people at home watching this on television and they can't see that part of the room to know that we have a full house here today. We have the Iroquois caucus here today, and we'll begin with 6 presentations from this group, limited to 10 minutes each. We have 2 hours. We need to be done at 5:30. So I'm going to restrict those presentations to 10 minutes, and I would ask for your cooperation in that regard. I'll give you a 1-minute warning. When you start your presentation, at one point I will just say 1 minute left, and that gives you an idea of your time so that you can wrap it up. And I only ask that because following those 6 presentations, which will take a little over an hour, we will have a round of questioning, and I know that many of the committee members would like to have the opportunity to ask questions. Depending on how long it takes us to get to that point, we'll at that point adjust to determine whether we have time for 1 round of questioning or whether we have time possibly for 2 rounds, but we'll cross that bridge when we come to it. First off, we are going to get a presentation from Chief Bill Montour on behalf of the entire group. And so I will, there's 10 minutes for that presentation, and following we'll have a second presentation from the 6 nations of the Grand River, which will also be given by Chief Montour. So I will give you 10 minutes, and if you finish your first presentation before that, then I'll just make that point, and then we'll carry on to the second one as well, okay? So with that, welcome Chief Montour, and you have 10 minutes.
Thank you, Mr. Chair, and honourable members of the Standing Committee on Aboriginal Affairs, Sego and Scano. Before I start, I would like to acknowledge that Grand Chief Stephen Bonsfield from Gunnesadagi is in the witnesses. He didn't get a chance to get his name on the list, so just want to make that point. Going on to the, my colleague Chief has asked me to make this statement on behalf of the caucus. In prehistoric times, the Iroquois formed a confederacy to ensure peace and unity, cooperation between 5 nations. We are referred to as the 5 Nations Confederacy and then the 6 Nations or the Iroquois Confederacy. Our original homelands stretch from the Niagara region in the west to as far as Quebec City in the east. Our people are still living in many communities throughout our territory. We still carry on inter-community trade, as we always have done. The Iroquois Confederacy is both military and sovereign political allies of the British and the Americans, and we've never given up our sovereignty, nor have we willingly ceded our land and territories. We still hold and exercise our original rights and freedoms. Ganawagi, Gunnesadagi, Akwesasne, Tyendinaga, Wata, 6 nations of the Grand River, and the Oneida of the Thames are the communities of the Iroquois Confederacy. Although we are separated by distance, we recognize that we are one people who share a common identity, common responsibilities, and our own system of law and government. Of our member communities, we have 4 of the largest of the 5 reserves in Canada. The elected councils of our communities have united in a political forum known as the Iroquois Caucus, and we represent the interests of our combined population of over 60,000 people. We have tried to have our issues and views presented through other processes and organizations. This has not worked for us. We have decided that now and in the future, we will represent ourselves at all regional, national, and international levels and speak on our own behalf. As one people, no other organization can represent us or speak for us without our express consent, including the Assembly of First Nations. Any agreements they enter into cannot be binding on us without our consent. As original nations of this continent, we have always maintained that we are nations within the meaning of international law and have never given up this status. As far back as the League of Nations, forerunner of the United Nations, we have sent delegations asserting our sovereignty and imploring the Crown to live up to her treaties with us. Our relationship is with the Crown is governed by the Turo Wampum, one of the oldest treaties in North America. It is interpreted to mean that in the same way as the two roads do not intersect, our respective governments also agreed not to interfere with each other. The purpose was to establish and maintain peace and friendship within our nations. The Turo defines our relationship by recognizing that we are equal but separate nations, and it forms the basis of all our treaties and agreements that followed. We have continually adhered to the relationship because it is our responsibility. We teach our children about this responsibility because they will inherit this responsibility after we're gone. Because peace is always desirable over a state of conflict, and friendship is a desired societal goal. But we find that Canada, who is responsible for this relationship on behalf of the Crown, does not honor the agreements made by its forebears. Rather than approaching the issues as allies and seeking a peaceful resolve, we are too often faced with unilateral decisions directed to us on how the issues will be handled. As a result, we find ourselves faced with the prospect of constant conflict. Our treaties with the Crown are vastly different from the so-called numbered treaties with Canada. Our pre-Confederation treaties are of governance, sharing, honor, and respect between the Crown and the Iroquois, which do not include extinguishment of our title. Let it be understood that settlements resulting from any process will not include any release of our lands, and no amount of money can replace our children's future in our lands. Our original relationship is represented by the Turo Wampum for the purposes of establishing peace and friendship between us. The occupations, protests, and even armed conflict that has been and continues to occur in our communities over land issues and claims is inconsistent with the intent of our relationship. It is a continual state of conflict that neither of us desire. As a result, we want this bill to be withdrawn. We recommend developing a fair process based on our original relationship with the Crown, a process in where reconcile our interests would achieve peaceful and more acceptable resolutions to settling grievances. We are prepared to work with the federal government in developing such a process. I have a summary of recommendations. I'll read two of them, and my colleague chiefs will jump in after me. The first one, we recommend developing a fair process based on our original relationship with the Crown, a process in which reconciling our interests could achieve peaceful and more acceptable resolution to settling grievances. The Iroquois Caucus is prepared to work with the federal government in developing such a process. Number two, Canada to withdraw this bill until a full and inclusive consultation has taken place with all affected Aboriginal nations through a process jointly designed with them and adequately funded. I'd ask my colleague Chief Randall Phillips to carry on.
Thank you, Bill. Recommendation number 3, the scope of claims has to be expanded to include all legal obligations arising from the fiduciary responsibility relationship and the honor of the Crown, including pre-Confederation treaties. Recommendation number 4, removal of Canada's perceived conflict of interest through the creation of a truly independent mechanism, which would report directly to Parliament and Aboriginal nations and partially provide funding resources to First Nations. Recommendation number 5, Aboriginal nations be provided adequate funding grants to enable them to pursue their claims and to create a more equitable and just process. Recommendation number 6, Canada cannot be exempted from punitive or exemplary damages. And I'll pass the next on to Chief Merkel.
It's Tim.
Recommendation number 7, compensation criteria should ensure Aboriginal nations are not discriminated against by the application of the Musqueam Court decision. Recommendation number 8, where Aboriginal title has not been ceded, access to and use of land for the Aboriginal nations must be included in the settlement agreement. Recommendation number 9, the extinguishment clause be removed from the requirement of all legislation and agreements. And I'll now turn to our Donald.
Recommendation number 11. An independent panel consists of at least 3 judges. Recommendation 12. At least 1 judge of the tribunal should be an Aboriginal judge. Recommendation 13. Funding should be decided and provided by an independent body. Recommendation 14. A special process for large claims must be developed jointly with Aboriginal nations and implemented as soon as possible.
Recommendation number 15, the Iroquois Caucus members have a specific exemption clause in the legislation until the large claim process is established. Recommendation 16, all elements of the political accord be included in the legislation. And finally, recommendation 17, the cap on settlements must be removed.
Complete. Well, thank you very much for that initial presentation from all of you on behalf of your umbrella organization. I would like now to move to the first of 5 presentations that will be made by the individual delegations, and so from the 6 nations of the Grand River. Chief Bill Montour again, please. 10 minutes.
Again, I want to thank you for the opportunity to appear before you. My time is short, so I'll cut to the chase. As I said, my name is Bill Montour, and I'm elected Chief of 6 Nations of the Grand River Council. We are located in southwest Ontario, just west of Hamilton. 6 Nations is the largest First Nation in Canada, with a total population over 22,000 citizens. We have less than 5% of our original land holdings as promised by the Huldman Treaty of 1784. That translates to less than 46,000 acres, of which the approximate 950,000 acres promised by the Crown to win our alliance with Britain throughout the Revolutionary Wars of Independence with the Americas. This number is significant because, as you can well see, the difference in these numbers indicate the volume of the so-called land claims with many years of compensation requires redress, and today's value of this land in southern Ontario makes many of our documented rights to land outside the scope of the financial cap contained in Bill C-30. Therefore, creative solutions will have to be implemented if the honour of the Crown is to be maintained and our treaties fulfilled. On November 2nd, 1796, 36 Mohawk, Oneida, Seneca, Onondaga, and Cayuga chiefs authorized Joseph Brant to surrender in trust to the Crown 4 blocks of land containing 302,907 acres for the purpose of establishing an annuity for the perpetual care and benefit of the 6 Nations. This was secured by a 999-year mortgages between 1798 and 1811. But covered only a portion of the lands as identified. Continuous revenues from the mortgaged lands no longer are deposited to the 6 Nation trust funds, nor have proper mortgages been entered into for all of the lands placed in trust with the Crown. In 1796, funds were treated for to secure our perpetual care and maintenance, should ensure our education needs are met to our standards, our health care needs are met to our standard, our social program needs are met to our standards, our housing and infrastructure needs are met to our standards. We are supportive of the Iroquois Caucus brief to this committee, but I would like to also make or reinforce a few key points. The duty to consult was not met with this bill. The duty to consult rests with the Crown, and 6 Nations was not consulted. This duty cannot be delegated to the others, such as the Assembly of First Nations. The Assembly of First Nations did not consult, nor was it the responsibility to consult. The duty to consult the right holders, this means our 6 Nation government, not organizations. I also understand that the AFN was forbidden by the federal government to share what they were working on. Number 2, this bill violates our treaties with the Crown, in particular the Goswenta or the Two-Road Treaty, where we agreed to not interfere with each other's affairs. Once again, the federal government is trying to impose legislation on us. This must stop. Number 3, 6 Nations is engaged in important, sensitive negotiations over lands and dispute at Caledonia and other parts of our treaty territory along the Grand River. We have been given a verbal assurance that this legislation will not apply to these negotiations and have even been given assurance we will receive a letter to that effect. However, we believe a letter will likely be overruled by this legislation. Therefore, we want an exemption from this legislation specific to Six Nations to be inserted in this legislation. 4, we would also like to see the protections contemplated in this bill transferred to the federal mandates and negotiators who are negotiating large claim settlements with Six Nations, such as time limits and removing of technical defenses. 5, lands must be on the table for negotiations. Six Nations of the Grand River's view is that lands must be returned to the Iroquois Nation equivalent to the same standing as held by the Haldimand Treaty or as specified by Six Nations. 6, settlements must mean certainty for both the Crown and Six Nations. We don't want you going back on your word or the intentions of written agreements as practiced by Crown agents in the past. At the same time, we do not want to see any extinguishment of our rights and interest to the lands in question. We can be very specific about what rights all parties are to receive. Extinguishment was never contemplated in our land dealings. We leased land, often through the Crown, as income for Six Nations and for perpetual care and maintenance of our territory and people. In specific areas, we welcomed people to share our territory upon lease conditions and under these terms conducive to our title to the lands being maintained and continuous ownership. I want to make a final comment on terminology and why this issue is important to us. Our attempts to obtain justice over our land rights issues have been termed land claims by the Canadian government. This term is wrong, and a new term should be found. We suggest perhaps First Name land reparations. We are not making a claim of land. If there is any doubt who owns the land for an incomplete or an illegal transaction, any doubt must fall on the side of the First Nation. It reverts back to Six Nations. The reason for these land reparations are important because they represent the potential to fulfill intended purposes of our land transactions. Again, the perpetual care and maintenance of our nation. They represent a way to provide economic development and to generate revenue to make our community self-sufficient. We need these resources through just settlements to fill the current funding gaps on so many issues important to our community, such as the provision of clean, safe water, the protection of our languages, cultures, traditions, ceremonies, the protection of our environment. All these things that are necessary for the perpetual care and maintenance of our people. That is why these just settlements must include more than cash. They must include the return of our lands and resources, which we never intended to part with. They must include justice. Nyawa, thank you very much.
Thank you very much, Chief Montour. Next, from the Oneida Nation of the Tams, I believe Martin Paulus will be beginning the presentation.
If I could, Mr. Chair, my name is Chief Randall Phillips, and I will be doing most of the presentation. Okay. But I'd also have invited up Councillor and Elder from our community, Olive Elm, and she will also be doing part of the presentation as well. Well,
yes, thank you very much for that, and we look forward to this. Mrs. Elm.
Thank you. Good afternoon, and I want to thank everybody for the opportunity to present our views to this committee on this bill. I want to first of all start by saying that I'm the elected chief of our community. I say elected because I make that distinction for two reasons. One is that our community is involved with traditional style of governance, and we still have title holders and clan mothers within our community. And I say that distinction to, one, respect them, and two, to make it clear that there is a distinction with regards to this notion of governance. So I put that as a preamble in terms of my statements there, Mr. Chair. The United Nations of the Thames generally supports the submissions by the Iroquois Caucus and their concerns about the proposed act to create a specific claims tribunal, Bill C-30. For example, we support the assertions that the Geswanta, or Turo Wampum, is an ancient treaty right of all Iroquois communities, and that C-30 is in a direct breach of this. That the Assembly of First Nations has no authority to represent our nations or our communities. That the federal duty to consult has not been met. that the tribunal as proposed is not independent, that land should be part of the specific claim settlements, and that imposing Bill C-30 is a direct breach of and a purported extinguishment of our existing Section 35 rights. Our ancestors immigrated to Canada circa 1840. The United Nations of the Thames was not granted any lands in Canada, but rather we purchased our settlement territory with our own funds. These funds were placed in trust within the Department of the day to purchase several tracts of our land for use and benefit of the United Nations of the Thames people. Consequently, many of our specific claims deal with the land itself. We have outstanding issues with Canada as to whether or not we've received as much land as we paid for, and whether or not we paid for certain tracts of land twice. Our territory is not whole. There are conspicuous absences in our land and in territory that we purchased. There are also issues of regaining the land that were once part of our purchased territory that have been lost by taxes or fraud or government agents. Our elders recount stories that indicate that our land holdings once extended far beyond the current recognized Oneida Nation of the Thames boundaries. Therefore, the provisions in Section 20, which refer to monetary compensations only, is simply not acceptable to the United Nation of the Thames. Entitlement to land we rightfully paid for will always be a contention of the United Nation of the Thames, regardless of what legislation is passed by Canada. The right to manage our own lands has been a hallmark of our internal justification of the United Nation of the Thames since we came to Canada in 1840. Currently, the United Nation of the Thames exercises inherent jurisdiction over internal matters such as land transfers, probate of estates, approving wills, appointing executors, and administrators of estates. Our jurisdiction originates outside the relevant Indian Act sections from an 1840 Order in Council which reads, under the circumstances representing a number of Indians coming into the province possessed of means to purchase land, the Council do not think the government is under any obligation to interfere with their affairs any more than the case of ordinary immigrants. And the state of civilization to which they are said to obtain makes it, in the opinion of the Council, advisable to leave them to their own discretion in the management of their property. Let me repeat that. Advise them to leave them to their own discretion in the management of their property. But they should also receive, when they require it, the advice, counsel, and protection of the Indian Department and of the government so as to assure the success of the settlement insofar as possible. That's an order in council granted August 14, 1840. The United Nation of the Thames has continuously exercised its internal jurisdiction and have operated our custom landholding system for the past 170 years in reliance of our rights as is stated in this order of council. Bill C-30, if implemented as proposed, would amount to a unilateral extinguishment of our rights arising from that order in council. Why? Because Section 4 of that Act says that the Act will prevail when there is a conflict between this Act and any other Act of Parliament. Oneida has a sui generis relationship with Canada when it comes to the land holdings and our rights to our territorial base. Passing this legislation amounts to a unilateral backdoor constitutional amendment because it eliminates or amends our Section 35 rights under the Constitution Act of 1982. Oneida Nation of the Thames demands that the federal government enter into negotiations immediately with our nation to reaffirm our ancient and existing rights with respect to our internal management of our lands, which has always been outside of the Indian Act. If I could, there's some specific issues that we have with Bill C-30, and I'd like to focus on those. Section 3 of the tribunal Section 3 gives the tribunal the power to determine the validity of claims as well as to decide any amount, if any, of compensation that is owed related to the claim. This is not an independent tribunal by any stretch of the imagination. If one looks at the combined effects of Section 3, 11, 14, 19, 20, and 35 of the bill, what you have is one party, called Canada, appointing the judge and jury who will be deciding the cases against themselves. This is an affront to the principles of natural justice. There is no judicial independence. We submit that this type of scheme would only bring the administration of justice into disrepair or disrepute. This process is fundamentally flawed. Maybe there might be some role for the tribunal and its expertise to determine what is fair compensation after there's been a determination of validity of the claim. But to have the same body determine both is unacceptable. Section 5, when viewed in conjunction with Section 34 and 35, creates a very real disincentive for First Nations to file with the tribunal, because in effect, if the tribunal declares your claim, denies you claim, automatically the government are released from any liability or any damages that may have been payable arising from the facts surrounding the claim in the first place. This renders First Nations right and appeals useless and redundant. Section 13 of the tribunal may hear evidence with respect to cultural diversity, but they cannot award any amount for the head under this claim of Section 2(1) D2, which is losses of spiritual and cultural nature. Section 13(2) demands repayment of monies provided to the claimant First Nations after a successful claim. This is offensive. Why should we have to pay for something that is Canada's fiduciary obligation and their duty to protect? That's our lands and our rights upon those lands. We agreed to be accountable, but this clawback provision is unacceptable. First Nations already must deal with the ridiculous bureaucratic red tape for grossly inadequate funding. This inherently limits what research we can conduct and thereby compromises our properly preparing of claims. Funding should be provided to First Nations with no strings attached. This government has unlimited resources. By contrast, we have very little. Section 23 is flawed because a province must consent to be bound by the terms of the decision of the tribunal. Provinces will never consent to be bound, yet they are the ones that First Nations oftentimes have claims against due to the divisions of power in the BNA Act. The limits placed also on the amount and the award are arbitrary and unreasonable. The ability for the Crown to take up to 5 years to pay in Section 36 is discriminatory because all other court judgments are fully payable immediately. In summary, the overall flavor of the bill is in the nature of reconciliation, which we hear a lot of from the Crown. Maybe the principles of compensation and restitution for First Nations losses should be guiding this process. Once those have been addressed, then possibly we could move forward in a form of reconciliation. The United Nations of the Thames has never been adequately consulted with regards to the potential effects of this draft legislation may have on our lands and our rights on those lands. No body, including the Assembly of First Nations, has been given the mandate to agree to this legislation on behalf of the United Nations of the Thames, or to negotiate what should be included in there. The United Nations of the Thames does not support this legislation. We will not consent to waiving our existing rights just so that we can have a claim considered by this process and the tribunal. There's also a conspicuous absence of a non-derogation clause. We feel this is because it is an explicit attempt to extinguish Section 35 Constitutional Act rights. The United Nations of the Thames should be negotiating directly with the federal government to resolve our outstanding land entitlement issues. In our case, any amount of money simply will not suffice. Getting the lands we rightfully paid for 170 years ago is our primary objective. In conclusion, I'd like to finish with our recommendation in the language.
Ne ci yatayo yan la ne nen on ku tu kwada hon chakelo dat sahau yo hanungo de ka bill yataya kwali wa ye na ti ka bill C30 ne ka di wa kwali wa ne ka ne dun to no ne ke ti ka bill dat ni ayuki to talo ci na te lo na ti lo slon ne aya kwala ko I da ya kwada li wa sken ha se ne a oli wa jot kun ne ant ka ye li ke ci kwada hon chakelo nen. Thank you,
Mr. Chair.
Well, thank you very much, Chief Phillips, and thank you, Mrs. Elm. Next is the Mohawks of the Bay of Quinte, and I believe that Chief Donald Miracle will be making the presentation. You have 10 minutes, sir.
Sego Sawat Guego. Hello, bonjour. Greetings from the Mohawks of the Bay of Quinte to the members of the House of Commons gathered here. The Mohawks of the Bay of Quinte are part of the Mohawk Nation within the Six Nations Confederacy. We are one of the Six Nations communities associated with the Iroquois Caucus and are a member of the Association of Iroquois and Allied Indians. The Tonondaga Mohawk Territory is located 8 miles east of Belleville and 50 miles west of the city of Kingston. Our membership is 7,724 members. We have a non-reserve population of 2,093. Our community has the 3rd largest membership of Aboriginal communities in Ontario, and we are the 6th largest Native community in Canada. And my research assistant will read our history.
Our ancestors were military allies of the British Crown during the American Revolution, as well as many previous wars between England and France. One of the many promises made to our ancestors was that our homeland villages would be restored at the end of the Revolutionary War. However, when the war ended with the signing of the 1783 Treaty of Paris, our homelands were given up by Britain to the American rebel forces. In recompense for the loss of the homeland villages and in recognition for their faithful military alliance with the British Crown, our ancestors were to select any of the unsettled lands in Upper Canada. As a result of this Crown promise, lands on the north shore of Lake Ontario were selected for settlement. These lands were not unknown to our ancestors as they were part of a vast northern territory controlled by the Six Nations Confederacy prior to the Royal Proclamation of 1763. Our ancestors arrived on the shores of the Bay of Quinte on May 22, 1784, only to find many Loyalist families were already squatting on the lands promised previously by the Crown. The Bay of Quinte is the birthplace of Daganowida, the peacemaker that brought the original Five Nations Iroquois Confederacy under a constitution of peace in the 12th century. When the Tuscaroras were adopted into the Confederacy around 1722, our people became known as the Six Nations Confederacy. After 9 years of reminding the Crown of promises made at the close of the war, the Six Nations were granted a smaller tract of land about the size of a township, approximately 92,700 acres on the Bay of Quinte. We received a deed to this land known as the Simcoe Deed, or Treaty 3.5. This document is dated April 1, 1793. Not long after we set up our village, many United Empire Loyalists came into the area. Within a span of 23 years, from 1820 to 1843, 2/3 of our treaty land base was lost as the government made provisions to accommodate settler families. Today, we have approximately 18,000 acres left of our treaty land base.
Our concerns with the proposed legislation. When we were informed about the development of new legislation to replace the specific claims policy, and when we heard the AFN was going to be involved in drafting the legislation, we anticipated a draft piece of legislation that would address the concerns of First Nations and that we would be consulted adequately because we would be affected by the legislation. We were disappointed to see that the legislation was introduced into the House of Commons prior to consultation. Instead, we are expected to provide a reactionary response to an already introduced bill with no guarantee that our concerns will be considered. We were further surprised to find out that the AFN was not able to discuss the proposed legislation with First Nations prior to it being introduced. Both Canada and the AFN have failed to consult with First Nations in any meaningful way prior to this legislation in the House. After the fact, we find that the proposed legislation resolves many of the federal government's administrative difficulties with the current policy, but does very little to address the title interests of First Nations. We have major concerns with this proposed legislation as it stands. After reviewing the proposed legislation, we reiterate and support all the comments that have been previously been presented by the Iroquois Caucus. We offer the following comments on specific aspects of the proposed legislation that fail to address the needs and interests of our community. This submission does not constitute consultation, but outlines our concerns with the proposed legislation. The conflict of interest. Canada has stated that this proposed legislation gets rid of the conflict of interest that exists with the current specific claims policy. In our view, the conflict of interest still prevails. Canada, through the Department of Indian Affairs, will still determine the validity of a claim and whether it will be accepted for negotiation or not, based on a legal opinion from the Department of Justice Canada. If the claim is not accepted or the claim is rejected under the proposed legislation, a First Nation will have the option of going to the tribunal. At the tribunal, a First Nations claim will be heard by a Superior Court judge that has been selected by the Department of Justice Canada and appointed by Canada. Given that Canada will retain control of the claim submission process and the appointment of judges, the conflict of interest has not been rectified. The lack of land as compensation, only monetary compensation. Our biggest concern with the proposed bill is that the lack of restoration of land as a form of compensation is not there. This legislation, as it stands, only provides monetary compensation, not land. This is an infringement on our rights under the Simcoe Deed Treaty 3.5, which is a constitutionally protected right under Canada's Constitution in Section 35. Our specific treaty states, and that in case any person or persons other than the said chiefs, warriors, women, and people of the said Six Nations shall, under pretense of any such title as aforesaid, presume to possess or occupy the said district or territory or any part or parcel thereof, that it shall be and may be lawful for us, our heirs and successors, at any time hereafter to enter upon the land so occupied and possessed by any other persons or persons other than the chiefs, warriors, women, and people of the said Six Nations, and them the said intruders thereof, and therefrom wholly to dispossess and evict and resume the same to ourselves, our heirs and successors. This means that the Crown or its heirs has a fiduciary duty to dispossess trespassers from our land. These treaty provisions embody the special relationship between the Mohawks and the British Crown as military allies and cannot be forgotten by subsequent layers of legislation. The current specific claims policy, entitled Outstanding Business, has a provision for land under compensation. Section 3.1 states, where a claimant band can establish that certain of its reserved lands were never lawfully surrendered or otherwise taken under legal authority, the band shall be compensated either by the return of these lands or payment of the current unimproved value of the lands. Compensation may include an amount based on the loss of use of the lands in question, where it can be established that the land in claimants did in fact suffer such a loss. In every case, the loss shall be the net loss. The Mohawks, the Bay of Quinte experience with the specific claims policy is that Canada's negotiators tend to turn a blind eye to the land compensation component of the policy. Canada's negotiators instead to follow an unwritten policy of monetary compensation only, and then advise its First Nations that they can use the settlement monies to purchase lands on a willing seller, willing buyer basis. Rather than recognize the fiduciary role to the treaty provisions of protecting the land, the Crown has instead followed a course of action toward extinguishment of Aboriginal title. The establishment of a tribunal to address monetary compensation only further ignores the treaty relationship that exists between our community and Canada. The only mandate we have from our community in negotiating land claims is to have the land returned to our growing population and to seek compensation for the loss of use of that land. Monetary compensation capped at $150 million. Under the proposed legislation, monetary compensation is set at a maximum of $150 million. This is a combination of current market value compensation and loss of use compensation. No amount of money can entice us to surrender our lands. Money does not address the Crown's responsibility to our treaty, nor is it addressing the growing need for restoration of our land base for generations to come. The tribunal will also not look at land claims over $150 million. Given the fact that our community has less than 20% of its treaty land left, with approximately 75,000 acres under potential claim, it is doubtful that our claims will fit into this process, especially when taking into account third-party developments on the claimed area. Forced extinguishment. The legislation requires First Nations to surrender all interests in or rights to the land and resources upon the settlement of a claim. The clause is also an infringement of our treaty rights under the Simcoe Deed Treaty 3.5, which outlines how the lands are to be disposed of, which reads, provided always nevertheless that of any such time the said chiefs, warriors, and women of the people of the said Six Nations should be inclined to dispose of and surrender their use and interest in the said district or territory, the same shall be purchased only for us in our name at some public meeting or assembly of chiefs, warriors, women of the people of the said Six Nations, to be held for that purpose by the government, lieutenant governor, or persons administering our government in the province of Upper Canada.
We're at 10 minutes, and we have your presentation, so it will form part of the record even if you do not have the opportunity to present it all. But if you'd like to take a minute, if you'd like to summarize before ending, if there are a couple of critical points that you would like to make.
We reiterate the comments that have been made by some of the previous chiefs, particularly with one judge being appointed. We find that's totally unacceptable. The political accords oftentimes are not lived up to by the Government of Canada. A good example is the Kelowna Accord, so we don't put too much stock in political accords. But the reality is that Canada has lawful obligations to protect our title to land. That obligation has been around since 1713. With the passing of the Treaty of Utrecht, the Crown is to be a protector of Six Nations lands, and has failed to do so. Our lands have experienced a lot of fraud and alienation, and as a result, the Crown should be purchasing land to settle these claims. Canada buys land for a lot of other purposes, and Canada should also include the purchasing of lands directly by Canada itself to settle claims.
Thank you very much, Chief. And one of the most difficult parts of this job is to sometimes have to limit presentations. I know that you've traveled to be here in Ottawa today, and we appreciate listening to you. As I said, for those of you who provide us with a written copy of the presentation, that is part of the record, and I know that members of the committee have either read it already or will read it. So anyway, thank you very much. The next presentation from Grand Chief Tim Thompson from the Mohawk Council of Akwesasne. You have 10 minutes, sir.
Thank you. Ladies and gentlemen, members of the Standing Committee on Aboriginal Affairs, First Nation communities, chiefs and councillors. My name is Tim Thompson. I am Grand Chief of the Mohawks of Akwesasne, a community of approximately 12,000 Mohawks who reside on ancient Aboriginal territory along the St. Lawrence River. Akwesasne has a unique geographical and political location between the countries of Canada and the U.S., the provinces of Ontario, Quebec, and New York State. Our community has been involved in several land claims with Canada over many years. Some of our claims are very large, some are currently being negotiated, some are being litigated, some have been in the process for more than 30 years, some have been rejected, and there will definitely be some Akwesasne claims that will be impacted by this legislation. We come to the Standing Committee because we have not been consulted on the new Specific Claims Tribunal, Bill C-30, and to bring our concerns forward on this impending legislation. We believe that the first of many shortcomings surrounding the new bill is a lack of direct consultation with First Nations communities. AFN does not represent the Mohawks of Akwesasne. We are a member of the Independent First Nations of Ontario and the Iroquois Caucus, neither of which have had meaningful consultation in this process. Some very important issues, such as claims over $150 million or some additions to reserve issues, have not yet been resolved, even though Canada and AFN recognize there are many unresolved issues with regard to this new legislation and have proposed that these concerns will be negotiated through political agreements with AFN. Without a consultation process, communities like Akwesasne will have no part in the building of legislation that will ultimately affect them. Akwesasne, therefore, does not know the future outcome of some very important issues if, in fact, will be consulted or if the issues will be resolved to our benefit. At present, Canada has aligned itself with the Assembly of First Nations as the main counterpoint to the negotiations to move the Bill C-30 through Parliament. Akwesasne considers this very political approach to consultation with First Nations inadequate. For important legislation such as this, which will impact the relationship of the Crown and the First Nations for decades, real and meaningful consultation must be held with all First Nations. Canadian courts have stressed that negotiations are preferable to litigation to resolve Aboriginal claims. The Specific Claims Tribunal will create a new level of litigation in claims with many of the disadvantages of the court. For example, the political nature of the claims permits them to address flexibility The tribunal, in contrast, would only be able to offer cash. The political nature of negotiations allow communities to have real control over the outcomes. The tribunal would give increased authority to the lawyers. In court, if you make a settlement of claim and the settlement of defense raises new issues, you have a right to reply. With the new tribunal, you have no rights to bring the evidence to refute the grounds of rejection of your claim. It appears to us that the tribunal has a more limited range of processes and remedies available to it than the Indian Claims Commission did. The present Indian Claims Commission has worked hard to establish a reputation for impartiality. We worry that the new tribunal will be seen as Canada's attempt to replace an impartial body with one that will be more favourable to the federal government's position. One of the most significant issues is the makeup of the tribunal. Currently, Bill C-30 proposes that Canada will appoint Superior Court judges, of which only one will hear any particular claim. We do not believe that decisions on courts should fall on just one judge. Additionally, the selection and appointment process for the members of the tribunal is non-reassuring. It is only in the political agreement, not the legislation. The consultation with AFN regarding the recommendation of judges to the tribunal is proposed. Depending on the makeup of the tribunal, it might provide federal claims officials and negotiators with an incentive to reject claims or have negotiations break down, as the tribunal could be seen as pro-federal rather than impartial. Bill C-30 will also create a more structured approach to specific claims, which will have the effect of providing very little flexibility to the tribunal to address the unique and complex circumstances which have created the claims in the first place. The new Act provides for monetary settlement only. Other creative solutions or options which may not be reasonable, productive, practical, or restorative will not be entertained. Most claims are about land. The fact that the tribunal can only award cash means it would not be able to address many claims in a way that would satisfy the claimants. The fact that the courts can deliver land at least more often than the federal system will promote litigation. Bill C-30 will completely eliminate the ability of First Nations to bring any discussions or studying relating to the social, cultural, and spiritual connection to the land as part of the negotiation process to settle a specific claim. Bill C-30 clearly makes this a non-negotiable issue. The political agreement states, resolving claims is a legal and moral obligation and recognizing the cultural, spiritual, social, and economic significance to a First Nation of recovering and replacing land that was unlawfully taken. The words are beautiful, but they fall far short of one important component. They do not allow for the discussion or negotiation regarding injuries to culture. They are associated with loss of land. First Nations know the impacts of injury to culture which have occurred with loss of land. This obvious injury should not be ignored. The new legislation proposes to exclude claims in excess of $150 million. This exclusion is something the AFN proposes to address through a political agreement. Meanwhile, its exclusion will allow government officials to coerce First Nations to artificially devalue their claims to fit the current criteria. With a cap on the size of the claim that the tribunal can address, federal negotiators will be tempted to collapse negotiations on large claims, knowing they have nowhere else to go, while there be pressure on First Nations to accept less than fair value for their claims to bring them under the cap if the claim goes to the tribunal. The presence of the tribunal as a process for settling smaller claims will be accentuated as a further excuse for avoiding settlement of larger claims. The larger claims represent the greatest benefit for First Nations and the greatest accumulated debt on part of the federal government. However, with a limited annual budget and a fascination with statistics, Canada prefers to resolve smaller claims. If the tribunal is not able to address the larger claims, these larger claims would be further deferred and become even less likely to be resolved. With the Cabinet looking at these claims, it surely shows that there will be no transparency with the decisions are made, as these decisions will be made behind closed doors. With the Iroquois caucus, many of our claims are above the $150 million. When Canada says there are 20 claims in excess of the $150 million, sitting at the table, there was probably 16 of those claims. One major obstacle to settling specific claims is the lack of clarity in Canadian law. Currently, only the courts can clarify the law, but litigation is currently being discouraged. Unless the rules and practices governing the claims process include those proposed for the tribunal are clarified and expanded, claims will remain unresolved. Bill C-30 also appears to place into legislation the retroactive surrender of lands originally taken illegally as a consequence of settling a specific claim and receiving compensation. There will be no future options available on this point if the legislation is passed by Parliament. In conclusion, I would like to say that AFN is not a First Nation and does not speak for all First Nations in Canada. Akwesasne wishes to make it abundantly clear that support by AFN does not translate into acceptance of this specific claim, Bill C-30, by the First Nations who are affected by this bill. It is important that Canada honour its obligations to First Nation communities, to consult with them regarding the legislation which will affect their claims and for their future. And before I end that, we make the following recommendations. A bona fide consultation process must occur with full participation of First Nation communities. Revisit the terms and references, capacity, authority, and remedies available to the tribunal. That the makeup of the tribunal should be composed of a variety of disciplines and should include First Nation members. And that the tribunal should be a 3-member panel, with one being a Superior Court Justice, with the other 2 members representing other related disciplines appropriate to the circumstances of the specific claims, all having an equal voice. That the settlement solutions available to the tribunal include land, financial, and other creative components in a manner that will satisfy the parties. The consultation with First Nations to ensure that the political agreement provides for the discussion on restorative justices with regard to injury to culture associated with the land. The consultation with First Nations to ensure that political agreement provides for with a discussion on claims above the $150 million. The consultation with First Nations occur to ensure that the political agreement provides for clarity in the rules and practices which are used in the settlement claim. The consultation with First Nations occur to ensure the political agreement provides for discussions on options regarding the surrender component of claim settlement. With that, I thank you.
Thank you, Grand Chief Thompson. And now for the 5th presentation from the Mohawk Council of Kanawake, Grand Chief Mike DeLille. You have 10 minutes, sir.
Thank you, Mr. Chairman. Just before I begin, I'd like to acknowledge the panel who is here today, as well as all the other chiefs and councillors who are here with our sister communities, our elders, the elder who has given me the opportunity to speak for us today on behalf of the people of Ganawage. I'm Grand Chief Mike DeLille, Jr. Greetings from the Mohawk community of Ganawage near Montreal. We're a community that has a significant place in the history of this country since before European contact. Ganawage itself has contributed to the establishment of the communities of Huron-Lowet-Wendage near Quebec City, Kanesatake at Oka, Quebec, Akwesasne near Cornwall, Ontario, Wata near Bala, Ontario, and Nipissing near Sturgeon Falls, Ontario. And we can trace some of our descendants to Manitoulin Island, Ontario, and Mitchell Band in Alberta. The Mohawks of Ganawage have been central to the founding of this country of Canada, and there exists a relationship between our peoples which can be traced to the relationship formed in pre-Confederation treaties. Peace, honor, and respect are our governing principles, and our relationship with Canada is based upon these founding principles. We take our Crown treaties and our relationship very seriously and are bound by the mutual promises made by the Crown and by our people. Our treaties are not the numbered treaties of Canada. We have asked and are called before you to comment on the proposed Bill C-30. This has been on our minds since the tabling of the proposed legislation, and we present the following concerns for your consideration. There has been a lack of broad consultation on the proposed legislation. The fact that the Assembly of First Nations has collaborated with the Government of Canada in this enterprise does not automatically mean that all Indian organizations or communities are in agreement with this most important and significant piece of legislation, since many communities are not represented by the organization known as the Assembly of First Nations. The fact that 4 Assembly of First Nations regional chiefs, all Westerners, and officials have worked hand in hand with the Prime Minister's Office and the Department of Indian Affairs to draft this legislation does not mean that all communities across this country have been consulted and or agree with or support this legislation. In fact, your committee has heard from one of the drafters of Bill C-30, Chief Lawrence Joseph, that no consultation on development of this content of the bill occurred. There are communities like Kahnawake who do not form part of the AFN structure. There is a national perception that the AFN represents all Aboriginal communities, and there is advanced celebration hailing the cooperative nature of the drafting of this legislation. There is a perception that all dissension on the issue of specific claims has been dissolved through the auspices and involvement of the AFN in the drafting of the legislation. We state for the record today that this is not so. The community of Kahnawake is fully able to negotiate and enter agreements without the assistance or approval of the AFN. And we will not be tripped up by the agreements and legislation that the national organization has entered without our approval or support. Agreement with this proposed legislation requires the full agreement and consent of the full Council of Kahnawake and other First Nations councils, not just a few chiefs in a closed meeting of the AFN. Kahnawake has a serious obligation to look at this legislation so as to avoid further conflicts with the Canadian people. While many Mohawk communities have grievances well over the proposed $150 million cap, the federal policies that are intrinsic to specific claims have the possibility of becoming the law and therefore having the power to overshadow negotiations of larger special grievances. We believe that this legislation would have the effect of tying the hands of the federal negotiators on possible win-win outcomes of negotiations. Such measures will leave our communities dissatisfied with any proposed settlement. This is not relationship building, and it is most important to keep in mind that the Iroquois communities in the eastern region of Canada, and particularly Kahnawake, has important grievances that have relevance particularly with the British Crown from 1760 onward. Our community wishes to be treated fairly, and the honour of the Crown demands that our lands be protected, as promised. Removing the large value grievances from the application of the tribunal process does not remove the impact of the legislation of these policies made into law. We believe that there will be an impact through the legislation of what was once policy, and that there will be a major splash effect on the larger grievances. When Kahnawake proposes new or creative solutions on our grievances, we don't want to hear from federal negotiators that their hands are tied by this legislation. While no amendments to proposed Bill C-30 are acceptable, here are issues that concern us, which are embedded in the proposed legislation. Bill C-30 proposes to make a law that will legislate all of the shortcomings of the current federal specific claims policy and Canada's approach to limit negotiations and offer inadequate monetary-only settlements for lands that have a great social, cultural, and spiritual connection for the Mohawks of Kahnawake. Money is not the solution here for us. We want land. Such legislation will likely impact all stages of the specific claim process, including larger claims valued over $150 million that need separate cabinet authority, which should include a resolution of those grievances outside the specific claim policy and which is inadequate to deal with special grievances. The proposed law would leave very little flexibility for the tribunal to address the uniqueness and complexities of historical land grievances submissions. Examples. The proposed bill will limit the compensation for a settlement to monetary values and limit options like return of land or other considerations that could be explored for resolutions. Furthermore, the bill should not permit Canada to download the responsibility for settling with the First Nations their valid land grievances to third parties, including the provinces, who can opt not to take part in the tribunal's proceedings and decision. The bill proposes the Crown would pay compensation only to the extent of their actions. And the Mohawks of Kahnawake do not agree that as a consequence of receiving compensation, all of our interests in these lands must be released to Canada. And in that process, that the third party's interests become retroactively validated to when the land was taken, which the Mohawks of Kahnawake believe would be unconstitutional. Why do we think this is unconstitutional? The Royal Proclamation requires lands to be alienated only to the Crown through its approval at public community meeting, specifically for that purpose. The Constitution says we have protections for our territories. Our treaties with the Crown say the same thing. The Constitution affirms my people's rights, and if the Government of Canada has a fiduciary obligation to protect our land, then how is that function served? What is being asked then is this First Nations giving up their right to their territories to third parties in a roundabout way or indirectly? How is it that the proposed Bill C-30 can ask my community to validate third-party rights over the rights of my own people? I believe that this legislation would be an end run around the Royal Proclamation. Again, to simplify, lands can only go to Crown by referendum of the whole community, and if the Constitution recognizes or affirms our rights, then we question the objectives of this proposed law, where third parties suddenly are positioned in advance of our ancestral rights to the lands. We have other treaties stating that the Crown promises to protect us in our lands, and this proposed law does not do this. It has the effect of superseding your Constitution indirectly. If you are not able to circumvent the Constitution or cannot do directly what you seek, then you cannot do this indirectly through this legislation. In fact, the 1982 specific claim policy allows return of lands, cash compensation, and other considerations. To be more detailed once again, the specific claims policy is problematic, yet Canada plans to legislate a more encompassing requirement for release of all interests in the lands that were illegally taken from our communities when the policy does not require release of all interests in alienated land. It is the interpretation of the Indian Act surrender clause that does, as a note. So legislation putting into law more restrictions is not conducive to settlement. Finally, the Crown, as well as the independent tribunal process, should promote reconciliation with particular emphasis on our historic and continuing relationship with the Crown. So it would be more appropriate to have the tribunal composed of individuals from a variety of disciplines and backgrounds, including First Nations individuals, not just Superior Court judges solely appointed by the Crown. Again, Canada has a legal obligation to consult all First Nations who could be impacted by Bill C-30. Considering that the requirement of retroactive release of all interests in favor of third parties does impact First Nations, this should trigger the obligation. In fact, all First Nations should be made aware of all proposed legislation and what the impact may mean for our communities. Consultation is a requirement that we see in extensive ongoing discussions on claims, yet the requirement seems one-sided since we are rushing this proposed legislation, a lack of consultation from the Crown side. The Mohawk Council of Kahnawake does not agree with the AFN's endorsement of Bill C-30, and Canada's consultation with the AFN is not sufficient nor acceptable, especially in consideration of my community's treaty history and current history where confrontations have occurred generated by lack of consultation. The Mohawks of Kahnawake also cannot support that AFN can represent us in the political agreement which was signed between AFN National Chief and the Minister of Indian Affairs on claims issues not addressed in Bill C-30. Lack of consultation is a breach of Canada's legal obligation and further tarnishes the honour of the Crown. If you continue on with the bill as is, without wider consultation, that would be a significant defect in your legislative process and could promote challenges to the legislation. In summary, the Mohawks of Kahnawake recommend that Canada be reminded of its constitutional obligations and not be allowed to propose legislation to indirectly do what they cannot do directly on the issue of First Nation lands. The Mohawks of Kahnawake recommend that the Standing Committee inform Parliament that Bill C-30 is flawed and is not ready to move forward, and no amendments will make Bill C-30 acceptable, and that Bill C-30 be withdrawn. The Mohawks of Kahnawake recommend that the Standing Committee inform Parliament that any future specialized tribunal developed pursuant to a bill must be truly representative of First Nations involvement, with a broader mandate and greater flexibility to address different steps in the resolution process and to take into account the wide variety of contexts. The Mohawks of Kahnawake are fully prepared to engage in consultation, developing a fair process with alternate approaches to resolving larger and smaller land grievances. We also recommend a principled approach that addresses our mutual concerns and furthers our relationship. This should be the basis for resolving grievances. Thank you, Mr. Chairman and committee members. Subject to any comments or questions, this is the presentation for the Mohawks of Kahnawake on this important proposed legislation. In the spirit of coexistence, we thank you.
Thank you very much, Grand Chief DeLeo. that completes our presentations, and now we will begin with questioning. The first round are 7 minutes each, and I'll begin with the Liberal Party. Ms. Keeper, you have 7 minutes. Pardon me.
They've changed their mind.
Oh, they've changed their mind. Ms.
Thank
Neville.
you. Thank you very much for being here today. Thank you very much for the thought and work that's gone into your presentation. It's certainly been a very powerful presentation. There's so many questions that are coming out of your presentation, and I've talked with some of you beforehand. You raised the issue of the duty to consult, and you certainly have your concerns about the process that was undertaken between the government and the Assembly of First Nations. In the best of worlds, how would you see a consultation process on this issue taking place? And I open that up to whomever would like to respond.
For those of you who'd like to respond, if you can just kind of give me an indication, and I'll. Okay, Chief Montour.
I would suggest that the Government of Canada, in any areas where there's going to be legislation proposed that's going to affect us, that you contact our community and ask for what our consultation protocol is.
Thank you, sir. Chief Phillips.
Yes, thank you, Mr. Chair. To me, the answer is simple, is that we already have traditional governments that had signed treaties here. Those are the people that we're talking to. Those are the people that this government should sit down and try to deal and resolve these issues with.
Thank you, sir. Chief Miracle.
There should be, to get away from the idea that one shoe will fit all feet, there could be very numerous pieces of legislation that are involved that are culturally appropriate to the First Nation that's involved. For example, the Iroquois communities may need a very specific process, and I think that our experts should be involved in jointly drafting the legislation with the government. And there should be an opportunity with that draft before it's tabled in the House of Commons to be discussed in our communities with our people.
Thank you, sir. Chief Thompson, Grand Chief Thompson.
I concur with Chief Miracle. If you want real consultation, then bring the hearing to the First Nation communities. Hear it directly. Hear what we have to say in our communities. Yeah.
And Grand Chief Talil, did you have anything to add?
Just maybe I concur with everything that's been said already, but also to stop utilizing the Assembly of First Nations as the sole authority, as the only source of information. As we've stated here today, and other people who are not with us here today have nationally stated that they don't speak on their behalf, and the duty to consult rests with the Crown. So it needs to be taken seriously by the Government of Canada, not utilizing just the Secretariat body of AFN. Yeah.
Okay, thank you. Ms. Keeper, you have just a little under 4 minutes left.
Oh, thank you very much, Mr. Chair. And I would like to thank our presenters. It was an excellent presentation, and it was certainly an important presentation in that the AFN has been in a joint process with Canada to write this piece of legislation. Many of the issues that you raised, the points that you raised around the tribunal's jurisdiction, broad release of rights, and the lack of consultation from your perspective. All of these issues have been raised numerous times at this table. I'd like to ask, though, I believe that Grand Chief Thompson made a statement in which he said that 16 of the 20 large claims, is that right? Is that correct?
16. There's a number of them sitting at this table today.
Right.
Canada says there's 20, and there's probably 10 or 12, maybe more than that, from this community that are large claims. I know Akwesasne is one of them.
Okay, I'd like to, on that point, ask all of you to comment on a presentation that was made here by the Canadian Bar Association. And one of the things they said is a peculiar aspect of the bill is what seems to be a rather arbitrary limit on the tribunal's monetary jurisdiction. And it goes on to say this limit could also operate to preclude the tribunal from adjudicating ancient historic claims, which are relatively straightforward in nature, but simply because of the time elapsed are now expensive to settle. This is an inappropriate restriction. Could you comment on whether you think that's a fair statement or whether you think it's pertinent for us to look at this in terms of the context of the large claims and in terms of the context of the jurisdiction of the tribunal?
Once again, I'll start on the left side and move across, and if you could just signal to me. So this would be Mr. Montour?
Yes. Yes, thank you so much. As far as the size of the claims, there are many that are going to be beyond the 120 million. And that's where we've got to come up with the creative solutions for that. Bringing forward these amounts, we're going to be eliminated. We're not going to be able to be one of the shoes that fit all the feet here. We're just not going to fit. What I think what's happened is we're going to miss the boat here, and the only way to get the attention of the government after that point, if the honor of the crown is not going to be withheld and come to the table freely, is we're going to have to get in people's face. This promotes the far more negative aspect of unsettled claims that we want to avoid. Just to give you a very small example, Caledonia itself, $50 million has been spent on that piece, and not one thing has been settled. And we're nowhere near settlement. And it's very, very unfortunate. When this was tabled in 1988, Canada sat on it, Canada sat on it, Canada sat on it. That's their resolution. They were afraid to face the reality of it. And that's where we are today. It's unfortunate, but that's the way it is.
Thank you. Chief Phillips, did you have anything to add?
Thank you, Mr. Chair. In response to your question, I think that what we're looking at is that the tribunal itself is I think inappropriate to answer your question. So the regards to this notion of limitations or restrictions on what the authorities that the tribunal does have could be tinkered with, but we're suggesting that it's not independent. There are too many flaws in it. So the answer in terms from Oneida is no, that there's nothing that could be done in terms of correcting the tribunal to address those issues. Thank you.
Chief Miracle?
The tribunal cannot exercise the rights of our people. The right to decide to alienate property rests with our people. That can't be exercised by any other party, including the tribunal. A large number of claims would be affecting our community. We have 13 different alienations. Many of them are, the legality of them are questionable. Also, the Crown cannot legislate away its fiduciary responsibility to our people to protect our land from fraud and trespass. And it's the fraud and trespass that we're trying to correct. And we're simply asking Canada to approach the parties that are occupying the land that we hold valid legal title to see if they would sell that land to the Crown so the Crown could do the honourable thing and return that land to our people.
Right. Grand Chief Thompson?
I think I made myself clear earlier that with the claims going forward of the 150 to Cabinet, there's no transparency there. Will there be consultations with individual First Nations, or will the Cabinet make a decision behind closed door outright with no consultation with the First Nations? That's a big issue for us.
Finally, Grand Chief Talil.
Thank you. How is it fundamentally different than when we put in a specific claim now that the scope and amount is determined, if not predetermined, by a body in Indian claims versus what would happen through a tribunal as it's prescribed within the law that the bill that we're talking about now that we've passed into law. And I mean, I hate to answer with a question, but how do you put a price on an acre or a hectare of tax-free land? So.
Thank you, sir. That completes this round. Next, Monsieur Lemay from the Bloc Québécois. You have 7 minutes, sir.
Oui, bonjour.
Good afternoon. I carefully listened to your answer to the questions, and I read your briefs very attentively about 2,859,994 questions, but maybe that would not be the case, so I'll try to go easy. I had an opportunity to read this document, and I understood that about 1/4 of the southern part of the province of Ontario, the government should sit down and negotiate with the Six Nations, something that it has never done since 1793, if I understand correctly. And now here's my question. Do you really think that with Bill C-30 we can settle here and now the claims of the Six Nations? The best evidence of this is that they are not even able to settle the Caledonia case with the government. So do you think that this bill will help us to settle a matter that has been there for 200 years? And I read your brief, the brief of the Iroquois caucus, and I find this point very interesting. On page, and I'll read it in French, but you can find it on page 4 of your brief, and it's very brief. The federal government wanted to be consulted by the AFN. Well, the answer is very simple. It can consult the same governments with which it signed the treaties, namely the 80 First Nations of Canada. And this poses a problem, or at least I have a problem. Do you believe that this would be a true consultation if those who have the treaties get consulted, whereas the government does not even honor the treaties it has signed? Do you not think that this would get you launched on an endless process with no end in sight? And I'd like to give you lots of time to answer, so I'll try to abbreviate my question. And we're friends, we're not politicking here. The federal government decided to recognize Quebec as a nation. We know what the result was. And you were there before we were there, and way, way, way before us. So, what is the solution so that the governments that succeed one another in power can respect your rights so as to avoid other Caledonias over the coming months? What is the solution? Some thought that be Bill C-30, and I clearly understood, and you don't need to repeat it to me, that for the Iroquois, Bill C-30 has absolutely no value. It is useless so long as the government hasn't sat down with them, and I've understood that. But what is the solution? So I wish you luck in answering me.
Once again, I'll start on the left with Chief Montour.
In terms of what we see as a settlement for the Six Nations of the Grand River, in 1794, the Haldeman Tract, 6 miles on either side of the Grand River from mouth to source, was made our lands. Those lands are what put there for our perpetual care and maintenance, meaning that those lands have to look after the 7th generation from my day on and from their day on. That's what we believe in. Our point is that we would like to sit down with Canada to start looking at the mortgages that have been of the 302,000 acres I alluded to before. And there's a bunch of leases called Joseph Brant leases that we should be getting some revenue back in addition to the province of Ontario on. There are lands claims at the south side going into the Lake Erie, where lands were sold, are surrendered but never sold. There's lands that were monies that were taken by the Crown trustees and used for various projects like the Welland Canal, the Grand River Navigation Committee, Our chiefs of that day had no idea what was going on with our money. So Canada has to come and sit down with us to look at our perpetual care and maintenance. Because there's no reason in my mind that I got to come to Ottawa and beg for a water plant when that should be there, based on that ancient agreement. You know.
Thank you. Chief Phillips, did you have something to say?
Yes, sir. Yes, sir. Thank you, Mr. Chair. Difficult question. I appreciate it. I don't think I need to take as much time as the member wants me to take to answer it, but I'm going to repeat what I said earlier, is that to resolve these things, you must go back and deal with the bodies that originally signed the treaties. Is that labor intensive? Possibly. Is that seemingly overwhelming? Possibly. But these things can't be fast-tracked, and I think this is what you're trying to do with the legislation. You're trying to move it forward, get it fast-tracked. But some of these issues you cannot put on that train. You need to sit down and do it specifically by community, nation by nation to out-resolve these things. There's no other alternative in terms of actually doing that work. So we talked about this notion that could it go on forever and ever and ever? Quite possibly. But what we're trying to talk about here and reinforce is that there's an honor of the Crown. There's an honor of the Crown in terms of trying to establish good faith negotiations and discussions with this. And if those things occur, then these processes could be sped up a lot quicker. Thank you.
Thank you, sir. Chief Miracle?
The solution is really a treaty land repatriation process that recognizes the Crown's lawful obligation to correct the mistakes that it has caused and the injury that it has caused our people. I don't think that we can ignore the passion that's in our young people. They see that our land base is totally inadequate to meet the needs for a prosperous future for our people. Many of the people that were added to our ban list with the passage of Bill C-31 do not own land. Our membership tripled with the passage of that legislation with inadequate consultation. So there's a passion and a fervor among our young people about the future, and they want the right to have the use and benefit of what rightfully belongs to them under our treaty. It is recognized that there's non-native people there, but perhaps there could be some sort of permit of occupation on a temporary basis there that would meet the terms and conditions of that permit of occupation would be prescribed by our people, so there would be some benefit for the use of our land during this transition period.
Thank you, sir. Grand Chief Thompson?
I think number one would be exemption to the process for the Iroquois communities, and give us a separate process. What process? We'd have to think about that and sit down as the Iroquois caucus and discuss that. Thank you.
Grand Chief Taleo?
Just to follow through on my fellow Chief Phillips's comment, I mean, there's got to be enough resource in Canada and in Quebec to be able to deal with these issues head-on. It took the federal government more than a decade to understand first and then realize the wrongs that they did through a large specific claim that they say it is, a long-standing grievance that we say it is, for 300 years. If it took the federal government in all its glory and authority and responsibility more than 10 years to understand and appreciate that, there is no way that any tribunal, any process can't take into consideration long-term implementation. We're not going anywhere. We don't believe our neighbors are going anywhere, but to put adequate resource instead of it going into the bureaucracy of the Department of Indian Affairs, I think would definitely help every First Nation across Canada, 600 plus, to sit down with somebody to discuss honor of the Crown, which is what our hope is in our specific grievance right now. So principle-based, and somebody on the other side of the table that agrees and acknowledges and has a direct line of communication with the people that can make law for this country, for the honor of the Crown. Yeah.
Thank you, sir. Next, Ms. Crowder from the NDP. You have 7 minutes.
Great. Thank you, Mr. Chair, and I want to thank you for coming before the committee and with some very well-prepared documents. And I'm like Mr. LeBay, I probably have more questions than I have time for. I think part of it is that you have identified a real challenge in that this is a fundamental issue of rights and title, as well as the fact that it's this particular piece of legislation doesn't recognize the differences in process from coast to coast to coast, whether it's the Proclamation of 1763, the numbered treaties. As I told some of you this morning, I come from a province where there's largely no treaties, and the challenges that that's presenting. In your presentations, there's a couple of points I want to touch on. One was, as we know, this legislation doesn't define a number of areas. So, for example, even if the legislation were to go forward, Section 16 talks about things like reasonable minimum standard, which are not defined in the legislation in terms of reasonable minimum standard for a claim to come forward. The transitional pieces are not defined in such a way that there's any assurance that it will actually do away with the specific claims backlog. A couple of you, I think Six Nations, I think Chief Montour touched on this verbal assurance that a negotiation that's in process will continue. The Okanagan band last week talked about a letter of comfort that they got that was ill-defined in terms of how their additions to reserve is going to go forward. The political agreement itself is vague and ill-defined. So I wonder if you could offer some suggestions. One of the things that Ganawagi identified was a beefed-up mediation process, a negotiation process, an alternate dispute resolution process. And a number of other witnesses have come forward with that as a suggestion, as a way to move this forward in a more respectful way. So I wonder if you could comment, first of all, on how some of the vagaries of this legislation could be locked down, and about perhaps looking at negotiation or mediation or alternate dispute resolution as another option.
Chief Montour.
The Six Nation position is that this piece of legislation can't do anything for us. So that's why we're requesting it be withdrawn. Thank you.
Chief Phillips.
Thank you, Mr. Chair. The position of the United Nations of the Thames is that this particular bill will be useless in terms of resolving any of our issues with respect to claims, and it should be withdrawn. Another independent body doing alternative dispute resolutions, I don't think is also warranted. It just adds to the complexity of the bill. Instead of trying to remove it for its flaws, we're adding band-aids to in terms of trying to put it. So another ADR process would not be appropriate in my mind. Thank you.
Thank you, sir. Chief Miracle.
The existing bill we view as being unconstitutional in that it doesn't meet the standards of the Royal Proclamation on how the Crown acquires title. It has to be with the informed consent of our people. Our people do not wish to surrender any more land to the Crown. We don't have enough land to accommodate our population already. And it's also a breach of our Treaty 3.5, the Simcoe Deed. And the legislation should be withdrawn.
Thank you, sir. Grand Chief Thompson.
I also agree with the other members, my fellow chiefs. It should be withdrawn, and there's no process. I mean, we have to sit here and sit with us directly and discuss it.
Grand Chief DeLeo.
I agree as well, not to restate everything that's been said, and my community decades ago has said not another inch. So we're not looking for amendments to this. It needs to be withdrawn.
Thank you, sir. Ms. Carter, you still have some time. So, sorry, Chief Miracle, did you want to add something?
Another point is that we believe that the bill violates the equality provisions under the Charter. Cash compensation should not always be forced on the Indian, where the title to the land goes to the non-Indian. We believe that's a form of discrimination on the grounds of race, and just want to make that observation.
Thanks. Ms. Crowder, you still have time?
Yeah, again, so to come back to Section 35 rights, I've heard you say that this is a constitutional issue. So if this bill were to proceed, do you see that there could be constitutional challenges that would come forward?
Who went? I think Ms.
Zachary Diom
wanted to say something. Maybe we'll go the opposite way this time.
Why we're saying constitutional invalidities is because this seems to be an end run around something that should be done a certain way. And I think all of you are acquainted with the certain ways. We have Crown treaties, 1760 Treaty of Oswegatchie, recognized by the Supreme Court in Siwi. And we've got also 1701 Treaty of Peace. We've got many, many treaties, and these treaties speak to protection of our lands. And these were incorporated, and the language is a lot similar when you come to the 1867 and to the Royal Proclamation. They're similar in there, in that they say, in order for lands to be alienated, there's a certain requirement. So suddenly, it's as though everybody is blind to this. And now it can be done simply through Bill C-30. That doesn't make sense to me. And on another matter, if I might just add, you know, you were talking about consultation, and just recently, last week I think it was, you signed the UN resolution, Declaration on the Rights of Indigenous Peoples.
Actually, the House of Commons passed a motion, but the government to date has refused to acknowledge that that's a legitimate.
In spite of the vote,
the majority of the House of Commons, the opposition parties, felt that the government should sign on to that, but the government, the Conservative government, has failed to agree. So we haven't, unfortunately, signed on.
In spite of a majority vote for. Very interesting. Anyway, it's very interesting for me from this perspective that in there, at Section 19, you see that states shall consult and cooperate in good faith with Indigenous peoples concerned with their own representative institutions, our own representative institutions, in order to obtain their free, prior, and informed consent before adopting and implementing legislative or administrative measures that may affect them. Today, we've told you that we think this will affect us, and we maintain that position. Thanks.
Grand Chief DeLille, did you have a comment? No? No? Yeah. Chief Phillips?
Thank you, Mr. Chair. I think going back to what the question was that would there be challenges if this would pass? And since we don't accept the bill in its face, since it's not going to provide us any benefit, then I would say yes, that there would be challenges to that, because what we've said is that there's provisions within that legislation that undermine our Constitution under Section 35 rights. Plain and simple. I don't know how else more we can put that in there. Going back to Ms. Crowder's answer, our question with regards to is there another process in terms of trying to deal with this? And I had said go back and talk to the treaties, talk to the people that you've dealt with the treaties, and I'll repeat that again. Why I say that is that these treaties weren't documents that were made overnight. You know, there was time, there was consideration, there was proper representation. It took an awful long time for the people to understand what was going on, how to deal with that, before they agreed to sign off on anything. And what we're trying to do now is to replicate a treaty process in 2 days, 3 days. Then again, I don't think that that's the right kind of mindset to take to this approach. That if we're going to resolve these issues, they did not occur overnight. They will not be resolved overnight. But if there is no movement in terms of trying to replicate that other process where these issues were dealt with, then we're going to continue to see the debates that we're having right now with respect to any movement on any government legislation. Thank you.
Thank you. Is there any further comments? No? Okay. With that, go to the last questioner from the Conservative Party, Mr. Bernuche. You have 7 minutes.
Thank you, Mr. Chair. Perhaps I might not be the last questioner, but we might have another round. I appreciate all of the testimony today from the members that have come before us from your various nations. I appreciate, of course, in a democracy, we also always have the opportunity to sometimes agree and other times disagree. I guess perhaps one particular point of testimony that I'll maybe ask a few questions on is just going back to Chief Phillips, some of your testimony. You mentioned that the tribunal that we're proposing is inappropriate, and you went on with some commentary. And I just wanted to speak a little towards why I believe the existing status quo is inappropriate. we have situations where specific claims that are being put forward by First Nations come to the government, and the government, as it currently stands, can either acknowledge those claims or not. And as such, the Government of Canada is the judge and jury on these claims. And many have said through the years, and I agree with that, that this is an unacceptable, inappropriate situation. The Specific Claims Commission came forward, but of course did not have any binding elements to it. When it would rule, it would bring forward recommendations to the Government of Canada, but the Government of Canada, again being as judge and jury, simply might choose not to proceed with those recommendations of the Commission. However, the new tribunal, which is being proposed through this legislation, would be an entity all to itself, which would actually have the opportunity to create binding settlements and actually deliver real dollars towards these specific claims. So it takes it out of the hands of the federal government, which many First Nations have argued have a bias to whether it be protect the public purse or protect itself from lawsuit. And so it's this very legislation which is, in my opinion, trying to set aside the inappropriate status quo. So I guess my question for you would be, do you believe that, in light of the fact that we have an inappropriate status quo where the Government of Canada is judge and jury, that this process, though perhaps not perfect, is in fact a departure from the status quo, and due to the fact that it is only voluntary, can't be at the very least seen to be a bad departure from the status quo? I would argue it's a good departure. So I guess maybe I just want to hear your feedback on what I've said.
Who would, Chief Montour, would you like to begin?
Actually, I was directing my question to Chief Phillips.
Oh, pardon me, Chief Phillips.
Well, thank you, Mr. Chair. I'm going to give a quick response, and then I'm going to see whether or not my counterpart here could add some of the more technical background. One of the things that I did say was about the inappropriateness of the tribunal was based on the objection that we don't think that it's independent to begin with. I would question whether or not the new tribunal or the new process that's being suggested is any departure from what did exist, and I'll tell you why I say that. Because at the beginning, at the front end, there's still a determination by the government of whether or not this is a valid claim or not. So that's a process that exists right now. Even though you might put the process in a 3-year time frame where the negotiations can come back and forth, then the tribunal can come in and say, okay, let's determine whether this. The tribunal again can determine the validity of this. So again, it might seem like it's an independent process, but it really is not. Does it speed up things? Sure. I think that's the approach that the government has done, and I think that's what the proponents of the legislation continue to announce, that it will speed things up. Where I said it was inappropriate was certainly inappropriate for our community, and that any kind of beefing up or using that tribunal would simply not be appropriate in that fashion. So does it beat status quo? Again, I think that there's incidences right now where status quo doesn't change at all. So I look at that, and I certainly do appreciate your comments with regards to the idea to agree to disagree. But I really don't see this as any real improvement with regards to the process right now. I don't see that it's going to be resolved in First Nations' favor down the line. I still think that the process is directed toward the federal government and the advantages at the federal government.
Well, perhaps if I could just ask another question for you, Chief Phillips. You mentioned in your last statement that you felt that because the government could decide whether or not a specific claim was valid or not, that nothing would change. And I just wanted to raise the point that that is the case. In fact, the federal government can continue to state whether or not it feels a specific claim is valid or not when it's negotiating with the First Nation. But at the point where it writes a letter to the First Nation saying that we don't feel this specific claim is valid, that's the point where the First Nation can then go to this independent tribunal, which an independent judge, you can debate whether or not judges in our country are independent. I think that for the most part they are. I mean, in theory, that is the case. We've seen many rulings across the country which surely don't go in favor of the federal government. And so at that point, then, you would have an independent judge who would rule on whether or not the specific claim is eligible. And so I guess I would argue a bit with you on that point, in the sense that once the government has decided that the government of Canada doesn't feel a specific claim is eligible for further negotiation, that's the whole point of this process. It allows for you then to take it to the next level, and within that process there will be a result. It's written to within the legislation itself. It guarantees a result either way. And so maybe my next question would be following up on the voluntary nature of this process. Due to the fact that your community doesn't need to engage in this process, do you feel that it should be made available to communities across the country that want to take part in the process?
If I could, Mr. Chair, make a kind of a partial response back to some of the earlier questions, and then I'd like to ask Martin to conclude on that. But I guess going back to this idea in terms of how this bill was moving forward, I suggest that the crafters of the bill were careful in its design to address those types of things, to put it in a flavor that would seem like it's an advancement moving forward, but I think that there's some very carefully worded clauses in there that accomplish quite the opposite. So we'll just have to wait and see how that goes. So with that, I'm going to pass the microphone on to Martin to address some of the other concerns. Thank you.
Thank you, Chair. I'll try to answer one of the questions that he asked previously. Do we think it's a bad departure from status quo? I think it is, yeah. Because right now we would at least have the rights of appeal maybe on two separate levels after the determination of validity at the court of first instance. But this eliminates that. It's like whatever the tribunal says with respect to validity, it solidifies our rights and takes away our rights of appeal. So I don't think it's any better than status quo. And the question back would be, would Canada agree to have a truly independent outside third party determine the validity of these claims? I think that's what we're looking for. We can't get over the fact that, you know, that the appointed judges are by Canada. So if we had an independent, truly independent party determining at least that part of it, then maybe the tribunal people could come in later and help to assess what compensation is fair, because they have the knowledge and background of the history and other awards in Canada. But to have somebody do the validity and the compensation determinations, I don't think that should be the first or the same person. I would like to see a process where Canada and none of its judges have any stake in it in determining the validity. Then I think it would be an improvement over the status quo. And we can't speak for other nations, but for us, I don't think it's an improvement.
Thank you.
No, you don't. Thank you very much. That completes the first round of 7 minutes, but we do have time to begin a second round. I'm not sure we'll be able to complete it, but Ms. Karatak-Lindell, you have 5 minutes.
Okay, thank you. I'm a little confused to begin with, but I guess my question is more on some of the statements you have made on pre-Confederation treaties. I understand that's a totally different area versus a lot of the other unsettled claims across the country. And so going on the same premise that, yes, one shoe does not fit everyone, I'm kind of wondering why you would not allow this legislation to go through to deal with the ones that can take advantage of it, for the ones where the shoe sort of fits, especially for BC or, you know, some other areas of the country where they feel that they can work within this legislation, and try to convince the government that there should be another process for maybe pre-Confederation claims? Like, is that an option where, as you say, some people said that you would ask for an exception to your claims? But having said that, there's also, again, the fact that it's a voluntary process. So in order to try and facilitate some movement on some files, wouldn't you want to see this go through and take care of some of those other claims on the premise that this would not prejudice your claims and not just your claims, but these types of claims?
Chief Montour, would you like to start?
If we can have certainty that other claims under the 150 or wherever there are in the numbered treaty areas in NNBC will not jeopardize our position, be our guest. But from the Six Nations point of view, any act that asks us to accept dollars for land rights settlement and then in turn asks us for certainty that we'll cede surrender forever is repugnant. Our community has stated very clearly, we will not sell another teaspoon of land. Thank you.
Chief Phillips, no?
Thank you very much, Mr. Chair. Real quick response. I certainly cannot speak for the other communities and see whether or not this is an advantage for them to move forward. I would only suspect that if I had the opportunity to explain to them what our concerns with the bill, that they might take a look at it differently. That's my only comment with respect to that. I think going back to the idea, too, in terms of how we talk about these things, I want to reiterate what we had said earlier in terms of the beginning at the Iroquois Caucus, and it said that we have a treaty relationship called the Turo, Gaswanta, and that extends to us in terms of other First Nations communities, too, and telling them what's good for them and what's not good for them. So I can appreciate your questioning us in terms of that regard, but as you're here, we're here as representatives of the Iroquois community, and this is what we're looking at here. So I can't or won't speak on behalf of any other community in terms of whether or not this is an advantage for them or a disadvantage for them. I don't know what they were told. We came here very clearly and told you that there was no consultation across this country. So perhaps maybe the reason why they're suspecting that it's a good thing for them was because of the same lack of consultation and the same lack of understanding of the threats that we see. Thank you.
Chief Miracle?
The bill will work for some communities. The communities that it will work for should be in a specific schedule that it applies to their communities, and it should be based on the local government of each community to decide whether or not they want this legislation to affect their community or not. Whether there's a treaty right that's pre-Confederation or not, it doesn't matter, because the treaty is alive and well prior to Confederation, and the same terms and conditions apply and are alive and well after Confederation. So if we have a treaty, for example, 3.5, that was made in 1793, that treaty was alive in 1793 with the same beneficial effect to our people, and the same beneficial effect is alive in 2008. And so we have an obligation to protect our treaty rights and to make sure that our treaty rights are not infringed upon or abrogated or extinguished or diminished, and this bill does that. It doesn't accomplish the goal of our people, which is land reparation of our traditional lands, regaining control of our traditional lands. It doesn't meet the goals and aspirations of our young people, and so there needs to be a treaty process. Since the government has always avoided honoring the treaties and upholding it in its fiduciary obligations, there is no process in place yet in Canada to do that. This could become the only game in town, where if you want to settle land claims, Canada is only willing to talk about money and not about the return of the land. And so that's the part that's silent, and that's the part that's threatening about this legislation, that it will become the only game in town. The other thing is that there's no provision in the bill for a non-derogation or non-abrogation clause, and so therefore it makes us question whether or not our treaty rights are being infringed upon through this legislation, and that is the intent of the government of the day to do that. So if communities want this legislation to apply to them, it should be by a decision of the community, and those committees should be named in a separate schedule.
Thank you, sir.
But it should not be a law of general application.
Grand Chief Thompson, did you have something?
I concur with Chief Montour with regard to certainty. Certainty also that there is an exemption for our First Nations, and that there is certainty that there's another process where the First Nations are directly involved in making that process.
Thank you. Grand Chief Talil, did you have anything to add?
I also concur. I think Chief Montour said it very well. To give example, you talked about timing and timeliness and how quickly this may resolve some things. I mean, and I know status quo is extremely frustrating for a lot of communities right now. We submitted one just about 10 years ago, and the response from the then negotiator said, we should have an answer for you by January, at the latest February. They just didn't tell us what year. We're still waiting.
Thank you, sir. Next, I think we're going to have time for two more turns, Mr. Albrook, and then one more for the block. So, Mr. Albrook, you have 5 minutes, please.
Okay, thank you, Mr. Chair. And I want to thank each of the witnesses for the time you've invested today. I think there's a possibility that in the consultation or talks today, whatever you want to determine that it is, that we focused primarily on the tribunal aspect of Bill C-30, and we've overlooked the possibility of negotiations occurring prior to going to the tribunal. And I think it's quite possible that in that negotiation phase, because of the eventuality of the tribunal, that there may in fact be productive discussions leading to creative solutions, which could possibly lead to settlements other than cash settlements. That's one point I would like to make, and maybe you could respond to that. The second one has been mentioned briefly, in that this whole process is voluntary. It's mentioned clearly in the preamble, and again in Section 5 of the bill, that the process is a voluntary process. It's clear to me that Bill C-30 was designed to address a very severe problem in the number of backlog cases of specific claims. This has been a problem for decades. The current system is obviously failing all of us, and it's failing First Nations people as well as other Canadians, all Canadians. So this is an attempt to move ahead on a process that will help the entire country, resolving outstanding claims. That's what all of us around this table want. I believe that's what everybody in this room wants, to move ahead. So my question is, would you rather continue with the status quo? Some groups have come here and have said, we need these amendments. At the end of the day, they said, well, we'd rather have the bill in its current form than risk an amendment possibly making it that the entire system bogs down. So my question is, would you rather live with the current system with its over 800 backlog cases? And then the second part of it, in terms of the cap of $150 million, it's my feeling that if we remove the large percentage of claims that are within the system now, the smaller claims, that it would in fact allow the bigger claims to have more attention by the department, so that these in fact could be settled. Could you care to respond to those questions?
Thank you, Mr. Albrecht. I'll start on my left with not Chief, but Mr. Montour.
Thank you. I don't know where this great will to sit down and negotiate in good faith is coming from all of a sudden. We've been at this for a long time. I mean, we've appeared before the Standing Committee, Chief Bill Montour and myself, in February 21st, 1991. Obviously, some of you are too young to even know that, especially the ladies on my right. If there's an extinguishment in place, I don't care what bill you put in. It just isn't going to cut it. It will not cut it in our community, period. It's got to be changed. There's got to be good faith negotiations. I totally agree with you. The policy, the Canada's specific claims policy, is a failure, no doubt. We were in there for 20-some years. All we did was stockpile validated land rights, claims that have been validated. We've got one on the table right now we're trying to harness. There's got to be creative solutions. There cannot be extinguishment of our children's rights in those lands. That's where it is. Thank you.
Thank you, Mr. Montour. Fortunately, Mr. Montour, when you're sitting at a round table, all the ladies are on your right. So, Chief Phillips, did you have something to add?
Thank you very much, Mr. Chair. Real quick in terms of that response, that there seems to be, I guess, some kind of assumption that the process is worth saving now. You know? What's stopping these backlogs of 800 claims is certainly not First Nations communities. It's the honor of the government. So, so when it comes to those types of things, in terms of whether you change the system or not, the honor of the government, the honor of the Crown still needs to be there. So the backlog can be easily done regardless of what system that you had in place. The reason why it's changing is because the other one simply didn't work, and there was too many controls by government to backlog the process. So I think that the government needs to look inward in terms of trying to move these things forward. Thank you.
Thank you, sir. Chief Miracle?
The current policy talks about, the first statement in the current policy talks about the return of the land as compensation. If we want to make that happen, the government is very apprehensive about beginning a process to do that. And if we simply ask Canada to go and approach the parties to buy the land to see if they're willing to sell their interest to Canada, that shouldn't be a complicated process. Canada is unwilling to do that for some reason or other. Canada buys land for all kinds of purposes in this country. Canada should be buying land to settle claims. At the tribunal, if we've heard loud and clear from all the chiefs here today that we're looking at regaining control of the land to satisfy the needs of our growing populations. The tribunal doesn't talk about the return of the land. It's strictly money, and extinguishing is not in our best interest for our future. So we can't endorse a policy that is about getting your land claim validated and then surrendering it to the government for cash. That does not meet the goals and aspirations of our communities.
Thank you, sir. Grand Chief Thompson?
The government can't even get the consultation right, and now they want to talk negotiation? Come on, give me a break here.
Grand Chief DeLeo?
Something interesting you mentioned, I don't consider this consultation. I would expect my brothers to agree with me, and sisters, sorry, to agree with me. Once we've gone to second reading and recognized this as the Aboriginal Standing Committee specific to this issue, it's a little late in terms of consultation. We've already stated, again, for the record today, we don't look for amendments to this or interim solutions. It needs to be scrapped. If we are talking to the people here representing the honor of the Crown, that message needs to be sent loud and clear back to the governments. My confrere, Mr. Zachary Diome, mentioned earlier about the UN declaration. I mean, it's an embarrassment, to be honest, at this point. And if we're going to be talking independence, then I would suggest if we want Canada to live up to its honor, then let's jointly appoint somebody from the international venue to overlook some of these larger grievances, as well as specifics that we've been alienated from our lands for so long now. So.
Thank you, sir, and thank you. Now, Monsieur Le May, if you have one quick question, we have a couple of minutes.
It will be very, very brief, because as you have noted, ladies and gentlemen, that some people tried to gang up on you to try to divide you. At least I noted that much. Another thing that I've noticed, and I would like you to read very closely, Section 34, Paragraph 2 of the proposed legislation. On the reserve of Paragraph 1, the decisions of the tribunal are not reviewable. They are final and have authority that over any other procedures taken with any other jurisdiction, so that once this is implemented, you all have lawyers, of course, that jurisprudence and case law will have the tribunal decisions applied to you in future negotiations.
Make a brief reply to Monsieur Le May's commentary? Seeing none? Miss No? Well, Monsieur Lemay, you got the last word. So, anyway, with that, I must conclude this meeting. I want to thank all of our witnesses and all of the other guests for being here today. We appreciate you coming to Ottawa and to making your presentations today, and your ideas and views will be carefully considered. We stand adjourned.